This is a presentation from the Connecticut Fair Housing Center on the basics of representing yourself in foreclosure and in foreclosure mediation. Most homeowners in Connecticut who are in foreclosure don't have an attorney representing them, so they're representing themselves. In a civil case, like a foreclosure, there's no right to a free lawyer if you can't afford one, and pro bono legal assistance is extremely limited. But there are resources to help homeowners represent themselves in foreclosure, including in foreclosure mediation. These resources include the Connecticut Fair Housing Center's Guide to Representing Yourself in Foreclosure, which is available on our website at www.ctfairhousing.org under the Foreclosure Prevention tab. This guide walks you through each step of the foreclosure process, explains legal terms, and gives you the forms and instructions you'll need to represent yourself. It also has tips on how to be successful in foreclosure mediation. The Connecticut Fair Housing Center also periodically offers legal clinics. These include a more detailed presentation on how to represent yourself in foreclosure and an opportunity to meet one-on-one with a volunteer, attorney, or paralegal to get advice or assistance. You can get the clinic schedule at our website, www.ctfairhousing.org, under the Foreclosure Prevention tab. The courts also offer weekly volunteer attorney tables at many of the courthouses. This is a chance to meet one-on-one with a volunteer attorney and get free legal advice about your foreclosure case on a one-time basis. You can get the schedule for the volunteer attorney program at the court's website, jud.ct.gov/volunteer_ATTY_PRGM.htm. Note that the volunteer attorney program is first come, first served, so it's best to get there early. It's also okay to get advice at a courthouse different than the one your case is at if this is more convenient for you. The Connecticut Fair Housing Center also takes referrals for legal advice sessions from housing counseling agencies. Housing counselors are not lawyers, but are a free resource to help homeowners work with their lender to avoid foreclosure. You can find a list of housing counseling agencies approved by the state on the website www.chfa.org. If you are in need of additional legal advice, your housing counselor may make a referral to our office. The foreclosure process in Connecticut is judicial, meaning the lender has to go to court and get permission from a judge in order to foreclose on a home. It can be overwhelming for homeowners because there is so much going on all at once. That's why it's very important to start keeping notes so you can stay organized. Foreclosure follows 3 tracks, meaning there are 3 processes going on, often all at once, that the homeowner has to stay on top of. The first track is servicer negotiation. Servicer means your bank or lender or whoever you send your regular monthly payments to. I'm going to use these terms interchangeably. This track includes talking to your lender about your options, perhaps sending documents to request a loan modification, and following up with them about missing documents or whatever programs are available. Servicer negotiation will continue throughout the foreclosure process, even if the lender hires an attorney or sues you in court to start a foreclosure. This is also the area where working with a housing counselor can be a huge help in understanding your options, gathering all the paperwork your lender will need, and negotiating with them. For the servicer negotiation track, it's very important to keep detailed notes of all conversations with your lender, including the name of the person you talk to. Keep all letters or emails you get from your lender and copies of what you send your lender. Keep track of deadlines, including deadlines to submit documents, to appeal the lender's decision on your options, to accept a loan modification, or to make trial payments. Many homeowners find a small notebook or a calendar are useful for keeping track of everything. Others prefer to make notes on the computer. Whatever system you use, though, keep copies of everything and write it down. The second track is the foreclosure lawsuit. This is when the lender files papers in court asking for permission to foreclose on, to take your house. Usually you will be at least 3 months behind before the lawsuit starts, but you may be further behind than this. Often there is no rhyme or reason as to when it starts. Don't think that because the lender hasn't started a foreclosure lawsuit, it's not going to, or that it can't. It could still be coming even if you are many months behind. With the foreclosure lawsuit, you will need to keep track of court dates, of documents the lender files in court, and the deadline for any response you need to file. The third track is foreclosure mediation. Foreclosure mediation is part of the court process, but it is separate from the main foreclosure lawsuit. The goal is to see whether you and the lender can reach an agreement to avoid foreclosure. You are only eligible for foreclosure mediation when the lawsuit has started. I will talk more about foreclosure mediation later on in this presentation, but there are two important things to know up front. First, foreclosure mediation puts an up to 8-month halt on the foreclosure lawsuit. That means that while you're in foreclosure mediation for up to 8 months, the lender can't foreclose on your house or push forward the foreclosure process against you. The lender has to focus on working with you in foreclosure mediation. Second, the overall success rate for foreclosure mediation is very high. Most homeowners reach an agreement with the lender in mediation to avoid foreclosure. Some portion of these are agreements to give up the home, but the majority keep the homeowner in their home. Nothing is guaranteed, but mediation works for many homeowners, even if they've tried and failed to work out something with their lender before. For mediation, it is important that you keep notes about your mediation appointments, the documents the lender or the mediator tells you to collect, and proof that you submitted those documents. As you can see with these 3 tracks, there is a lot going on all at once, so notes are incredibly important. Even though the lender is involved in all 3 of these processes, it's often not the same department. The representatives you talk to on the phone may not know what's happening in foreclosure mediation or part of the main foreclosure lawsuit, and vice versa. Don't rely on your lender to keep track of everything. This is something you need to do. The first indication you'll have that a foreclosure lawsuit is coming is the notice of intent to accelerate. This is a letter from your lender asking you to pay all the payments you've missed in 30 days, or else the whole amount of the debt will come due. But even if you are not able to pay, the lender still has to take you to court. You may also receive letters from the lender's attorneys, but this doesn't necessarily mean you're in foreclosure yet. The foreclosure lawsuit officially starts when you're served with a summons and complaint package by a marshal. This will be a thick stack of court papers and forms. The marshal will typically leave them in your porch or on your front door. The marshal does not have to actually hand you these papers. Leaving it at your house is enough. It's a good idea to be on the lookout for the summons and complaint package if you think a foreclosure may be coming, since there are deadlines for you to file forms in response. Once you get the summons and complaint, this is the point where you can request mediation and get the up to 8-month halt on the foreclosure lawsuit. The 2 forms you'll need to file with the court are the appearance form and the foreclosure mediation certificate. Copies of both forms will be included in the summons and complaint package. You can also get them from a courthouse, the court's website, or in the back of our guide to representing yourself in foreclosure. The deadline to file both of these forms is 15 days after the return date. The return date is a date that will be listed on the summons. It is not a court date, it is not the date you will lose your house, and you don't have to go to court then or file anything on that date. The return date just starts the 15 days for you to get in the 2 forms. The appearance form mostly asks you for your contact information so the court knows where to send notices and how to get in touch with you. It's important to file this so the court knows that you want to participate in your case. The foreclosure mediation certificate is what you need to file to get into foreclosure mediation and get that up to 8-month halt on the foreclosure process. This form looks much more complicated than it actually is. For 99% of situations, it's just asking a few yes or no questions to make sure you are eligible for foreclosure mediation. It's asking, is this your home? Is it your primary residence? Is it a 1 to 4 family home in the state of Connecticut? Are you the borrower? And is this a mortgage foreclosure? If you can answer yes to all of these questions, then you are eligible for foreclosure mediation. Filing this form and your appearance form by the deadline of 15 days after the return date will get you into mediation, and the 8-month hold will start. But there are some situations where homeowners will not be eligible for foreclosure mediation. For example, if the house the lender is foreclosing on is your vacation home or an investment property, then it's not your primary residence, so you wouldn't be eligible for mediation. Or if this is a foreclosure by the town or a sewer company because of unpaid taxes or sewer charges, that is not a mortgage foreclosure, so you're not eligible for mediation. Or if it's a foreclosure brought by your condo association because of unpaid common charges, then it's not a mortgage foreclosure either, so you will not be eligible for mediation. but if you can truthfully answer yes to the questions on the form, you will be eligible for mediation. Again, the deadline to submit the 2 forms, the appearance form and the foreclosure mediation certificate, is 15 days after the return date, which will be listed on the summons. Now I'm going to talk more about foreclosure mediation. The goal of mediation is to see whether you and your lender can reach an agreement to avoid foreclosure. This could be something like a loan modification, which is restructuring your debt that keeps you in your home, or an agreement to leave through something like a short sale. Mediation happens at the courthouse, but not in a formal setting like a courtroom. Usually mediations are held in small conference rooms or offices. It is much more informal and more comfortable for most homeowners than appearing in court in front of a judge. The mediator is a court employee, usually an attorney who works for the court. They are neutral. That means they're not your advocate or the bank's advocate. Mediators are trained in foreclosure laws and all the programs that are available to homeowners. Most foreclosure mediators in Connecticut primarily mediate foreclosure cases, so they are very familiar with what homeowners are going through and the struggles they often have working with their lender. The mediator's job is to push you and push the lender to see if you can reach an agreement. For you, that may mean pushing you to get all the information the bank needs and to supplement it as needed. For the lender, that may mean pushing them to properly review you for all the programs that are available. Foreclosure mediation has 2 phases. First, pre-mediation, and then the main mediation process with your lender. During the first phase, pre-mediation, homeowners meet one-on-one with the mediator to complete the forms and collect the documents the lender will need to evaluate your request to avoid foreclosure. Within about 5 weeks after your return date, you'll get a packet of forms and other information about your loan from your lender's attorney. Around the same time, you'll get a notice from the court with your first one-on-one pre-mediation meeting with the mediator. Do your best to complete the forms and gather the information before your first meeting with the mediator. The mediator will talk to you more about your situation and help you figure out what else is needed. There may be more than one pre-mediation meeting. Once the mediator is satisfied that you have all of the information the lender needs, the mediator will send your documents to the lender and you'll enter the second phase, mediation with the lender. You'll get your first mediation appointment, that is a meeting with the mediator and the lender's attorney to try to work something out. Usually the lender will not be present, although there may be a representative on the phone. The mediator has discretion not to refer cases to mediation. For example, if the homeowner is not participating. It is very important to go to your appointments and to gather the information the lender needs so that you can stay in mediation, get the benefit of that hold on the rest of your foreclosure case, and your best chance to work something out with your lender. The vast majority of homeowners who participate in foreclosure mediation end up reaching an agreement with the lender to avoid foreclosure. Most, but not all, will reach an agreement that keeps them in their home. Fewer than 25% of homeowners in mediation have a lawyer representing them. If you're representing yourself, then you are certainly not alone. Even if you've had difficulty working with your lender in the past, or if the lender has previously told you there were no options for you, mediation may result in you reaching an agreement. It's common for homeowners who've been denied for loan modifications, sometimes even multiple times, to be approved for one in mediation. But of course, nothing is guaranteed, although participating in mediation is generally your best chance to work out a deal with your lender. Now I'm going to give you some tips on how to be successful in mediation. These are the 4 P's: plan, proof, push, and patience. The first P is plan. You should be prepared to explain your story in 30 seconds or less. What happened, what you want now, and your plan for getting there. For example, your 30-second story could be something as simple as, I fell behind on my mortgage when my spouse's hours were cut at work and our income dropped by a third. My goal is to keep the house, and I'm working with a housing counselor to apply for a loan modification, and I'm also looking for a second part-time job to increase our income. I know from working with homeowners for many years that it's often the perfect storm of events that result in people ending up in foreclosure, and it's incredibly hard to distill all of this down to something so short. It's important to give a short description of what happened and what your hardship was, but you don't need to give the blow-by-blow of everything that happened or everything that the lender did wrong. The focus of mediation is getting out of foreclosure, so it's important to emphasize what your goal is and how you're going to get there. For many people, their goal will be staying in their home. Usually this will be through a loan modification, which means the lender is restructuring your debt so that you come current on your loan and hopefully have more affordable payments going forward. But it's also okay to have a different goal, like staying in the house till the end of the school year or working out a short sale with the lender. It's also perfectly fine for your goal to change. The next P is proof. Hopefully by now you are keeping very detailed notes. Bring those with you to mediation. Also bring extra copies of everything you've submitted to the lender, even if it was a while ago, and fax confirmation pages if you submitted via fax. Always try to submit documents in a way that will allow you to prove that you submitted them. You could do it through the mediator, via fax, or if the lender will allow it, via email. It's not a secret that lenders sometimes misplace or lose documents. Fair or not, usually the burden will be on you to prove that you submitted them and did what you were supposed to do. It's much more effective if you can consult your notes and explain that you submitted the supposedly missing pay stubs on September 14th, that you confirmed with Judy at the lender that they received them, and perhaps provide a fax confirmation page, versus if you just say you submitted them a couple months ago. Occasionally, a lender will also ask to see some obscure document you submitted many months ago. Your mediation session will be more productive if you can whip it out then and there rather than having to look for it later. The third P is push. Your lender may tell you no, nothing is possible, your loan can't be modified, you have no options, but I urge you to push back and not accept no until you've done some digging. Lenders make mistakes, sometimes even with simple math. If you've been denied for something like a loan modification, you should always ask for the denial and the reasons in writing. They should always be giving it to you in writing, but sometimes this still doesn't happen or their reasoning isn't clear. Most loan modifications are largely mathematical formulas. The lender inputs some numbers and the computer says whether or not the loan can be modified and the terms. Because of this, it's very important to get the numbers the lender used in evaluating your request. The two most important numbers are 1, your monthly income, and 2, what the lender says your house is worth. Your income is important because many loan modification programs are targeted at your income, or you may not be approved if your income is too little or sometimes even too much. This is also an area where we frequently see lenders making mistakes. This is especially true if someone has a second job, is self-employed, or gets tips or bonuses. Find out what they think you make and double check that this is actually right. House value is important because many loan modification programs also assess whether it would be more profitable to foreclose on your house and sell it, or to restructure your loan, meaning the lender will probably get less money from you per month than they originally bargained for. If they think your house is worth a lot, then they may be less willing to give you a loan modification because foreclosing and selling the house will look more attractive. But lenders usually are not doing full appraisals and may be relying on drive-bys or computer-generated guesses as to the value of your home. So the house value they have is not always accurate. You may be able to provide other evidence as to your home's value, which sometimes can change their decision. But the main takeaway here is not to give up and to push back. To do this, you will need to understand the reasons behind their decision. Your housing counselor and your mediator can also be helpful in assessing whether or not the lender may have made a mistake. The final P is patience. Usually you won't reach a resolution at your first mediation. The average length of time a homeowner is in mediation is 9 months, although the goal is to reach a resolution within 3 mediation sessions over 7 months. Mediations are typically scheduled a month or two apart, and it's not enough just to show up. You need to continue to be persistent and to negotiate with your lender. Remember that the servicer negotiation track continues throughout the foreclosure and the mediation process. Call your lender in between mediations and confirm that they got your documents and have everything that they need. Submit documents between mediation so you don't have to wait till you see the bank's lawyer in person. Be as proactive as possible. There's not much you can control about the foreclosure process as a homeowner other than how engaged and persistent you are in trying to resolve it. Now I'm going to talk briefly about what to do if mediation does not work out and the foreclosure lawsuit picks back up again. At this point, you may want to file an answer in special defenses, but this is an optional step. An answer is your response to what the lender is saying happened. Usually they're saying you didn't make your mortgage payments. A special defense is your argument for why, even if this is true, you should still win and the lender shouldn't be able to foreclose. Again, both the answer and the special defenses are optional. It's very important if you're considering raising a special defense that you are specific and, if possible, that you consult with a lawyer. You can look at the list of legal resources at the beginning of this presentation for some ideas. Not all cases will have a special defense. In the majority of situations, there will not be a reason for the judge to stop the foreclosure if you are behind on payments, even if the lender has done something wrong. Because an answer and special defenses create more work for the lender's attorneys fees that are ultimately added to your mortgage account, you should carefully assess whether or not you have a defense before deciding to pursue this optional step. Special defenses need to be specific to your loan. General issues like the greed of lenders or technical sounding issues with the note or the mortgage typically will not give you a special defense. The fact that you had a bad loan or were ripped off may not give you a special defense either. Your personal hardships or the harm you would suffer if you lost your home generally do not give you a special defense, although the judge may give you extra time in your house at the back end of the case. Examples of special defenses might be if you had a loan modification but the lender wasn't honoring it, or if the lender was supposed to give you a forbearance, a temporary pause on payments, and is foreclosing anyways, or if you were paying but the payments were misapplied. If there's something wrong with the lender's complaint, then this is something you may want to raise in the answer portion. Again, the answer and special defenses are optional steps, and it's best to consult with a lawyer before filing either. If you do have to see the judge in court, it will probably be for something called short calendar. Short calendar is when the judge makes decisions in many foreclosure cases, which will all be scheduled for a court hearing at the same date and time. Unfortunately, short calendar is not very short. You will get a notice in the mail telling you to go to court on a certain date, typically a Monday. On the Friday before your short calendar date, call the court clerk's office and confirm that your case will actually be heard on your date. The reason is that cases automatically get scheduled for short calendar hearings when one side files something with the court. But if that side doesn't call the court beforehand and affirm that they want the judge to hear their case that day, the short calendar hearing won't happen. Always call to confirm on the Friday before that you will actually have court so you don't end up wasting a day in court for nothing. If you need a language interpreter, try to request one in advance from the court. There is sometimes a shortage of language interpreters. If you have a short calendar hearing, it will probably be for a foreclosure judgment motion. That means the lender is asking the judge to set a date to foreclose on your house. There are two ways foreclosure happens in Connecticut. The first is a foreclosure sale, an auction, what most of us think about when we imagine a foreclosure. The judge will set a sale date, a sign will go up, and at noon on that date, the house will be auctioned off to the highest bidder. Foreclosure sales are somewhat unusual and only happen if a person has a fair amount of equity in the property or if the United States has a lien on the property. Otherwise, the far more common process is called strict foreclosure. Strict foreclosure is much quieter. There won't be an auction. The judge will select a date in the future called a law day. The law day is the last day you will be the owner of the house. After the law day, ownership of the house will go to the lender and you will have lost your home. A strict foreclosure is quieter, but it's every bit as real as a foreclosure sale. Note that a foreclosure judgment hearing can't happen until mediation is over, even if the 8-month halt on the case is up. Also note that the judge has a lot of discretion in deciding when the foreclosure sale or the law day happens. So even though you might not have been able to raise your personal hardships as a special defense, this is an area where the judge can take this into consideration and give you additional time in your home. If a foreclosure sale date or a law day gets set in your case, that doesn't mean you have to give up. But it's incredibly important that you go back to court and ask to delay the law day or foreclosure sale before it passes. The judge has discretion to delay the foreclosure up until it happens. But once a law day has passed, it's almost always too late for the judge to undo it. To ask for more time, you would file a motion to open judgment. You need to file it with the court and have it heard by the judge before your law day passes or the foreclosure sale happens. Otherwise, it may be too late. If you file a motion to open, you would also get a short calendar hearing date. You would need to call the clerk's office the week beforehand, Tuesday through Thursday, and confirm that you want the judge to hear your case on your short calendar date, called marking your case ready. When it comes to a foreclosure date, it's very important to listen to what the court tells you is going to happen and not what the lender is telling you. Even if the lender tells you the foreclosure is not going to happen, if your law day hasn't been postponed by the court, you may still lose your home. When in doubt, file a motion to open to protect yourself before the foreclosure sale or law day passes. In a few courts, judges also hear requests related to foreclosure mediation at short calendar hearings. This would typically be if you want more mediation sessions and the lender disagrees, or if the lender wants mediation to end for some reason. No matter what brings you to court, it's important that you keep everything you say short and focused. You should have another 30-second story ready. What you want and why you should get this. Judges make decisions quickly, often in 5 minutes or less. It's not going to be your day in court to hash out everything that's gone wrong. Lead with what you want and then provide some information about why this should happen. It's a good idea to practice, and it's also okay to write something out beforehand to just read. But be brief and stay focused. Even though predatory loans don't always give homeowners a defense to a foreclosure action, predatory lending and lending discrimination are on the Connecticut Fair Housing Center's radar and are something we're actively working to stop. Our mission is to end housing discrimination in Connecticut, to combat racial segregation in our cities and towns, and to ensure that all residents have access to the housing of their choice. Race and national origin discrimination often show up in lending as giving Black and Latinx borrowers worse loans than white borrowers, even if they were more qualified. Examples could be higher interest rates or just more expensive loans. It can also occur as refusing to give loans to Black and Latinx borrowers or to lend in neighborhoods that people of color predominantly reside in. It can also happen when real estate agents or lenders steer homeowners into certain neighborhoods and not others based on their race or national origin. All of these forms of discrimination contribute to making Connecticut one of the most segregated states in the nation, where towns and cities right next to each other sometimes have populations that are almost entirely white or almost entirely non-white. Discrimination can also show up in the loan modification process. For example, Black and Latinx borrowers, or those who aren't fluent in English, might be treated worse than white borrowers or borrowers who are fluent in English. Sometimes lenders will refuse to consider public benefits like disability or Social Security or self-employment income, which could be source of income discrimination or disability discrimination. These are issues that we're working on and problems to be on the lookout for. Many homeowners ask us if bankruptcy can save their homes. Usually it makes sense to wait to start a bankruptcy, but it's a good idea to talk to a local experienced with foreclosure bankruptcy attorney early on. You can find bankruptcy lawyers in Connecticut from the website www.nacba.org. But bankruptcy usually will not save your house. It may get rid of your personal liability to pay the debt, meaning your lender won't be able to go after your bank account or wages, but it generally won't get rid of the mortgage itself. That means the lender can still foreclose. A Chapter 13 bankruptcy, a repayment plan bankruptcy, can be an option if your income has fully recovered and you can afford to pay your old mortgage payment plus extra to get you caught back up after 3 to 5 years. The more common Chapter 7 bankruptcy typically won't save your house though, but it can be helpful if you have a lot of other debt like credit cards or medical bills. Either way, bankruptcy is not something you generally want to do on your own. Talk to an experienced bankruptcy attorney and do so early in the process. Finally, I'm going to give you some information about scams to watch out for. Once you are in the foreclosure process, and sometimes even before, you will probably start getting letters, emails, and even phone calls from people and companies offering you all sorts of things. Promising a loan modification, promising to refinance, promising to tell you what's wrong with your loan so you can defeat the foreclosure. These are almost certainly scams. If it sounds too good to be true, it probably is, and it's probably a scam. No one can promise you a loan modification. This is ultimately the lender's decision, and you shouldn't pay anyone money to get a loan modification. This is not going to increase your chances. There's free help available through HUD and CHFA certified housing counselors. These are far better than the for-pay scammers that promise to do this for you. Also, watch out for forensic audits. These companies often promise to tell you, for a fee of course, what's supposedly wrong with your loan. But as we talked about, this generally isn't going to be a basis for a defense in Connecticut, and any real problems with your loan are not something the scammer is going to be able to uncover. Unfortunately, many scammers are out-of-state lawyers or are posing as out-of-state lawyers. It's a crime to practice law in Connecticut if you aren't licensed here. You should not hire an out-of-state law firm to represent you or to offer help behind the scenes. If you decide to hire a foreclosure defense lawyer, it should be someone who's local, who's licensed in Connecticut, who's experienced in foreclosure defense, and willing to go to court for you. If you do think you've been scammed, you can make a complaint to the Connecticut Department of Banking. Their number is 1-877-472-8313. Thank you for watching this presentation from the Connecticut Fair Housing Center about representing yourself in foreclosure and in foreclosure mediation. You can visit our website at www.ctfairhousing.org and click on the Foreclosure Prevention tab for a copy of our manual on representing yourself in foreclosure and more resources.